Okay, if you have questions, hold the sheet up, and Mel, are you here? Can you help us gather up the questions? While we're gathering them up, go to your evaluation form and work on that for now while we sort through the questions. Take this one. Kevan.
Insurance. Okay.
Sue.
Okay, I got one that says, what are limited common elements? A limited common element is a common element that is pertinent to a specific unit. So sometimes, say, a lanai may be a limited common element. Only one owner gets to use that common element, you know, and so that's why it's limited. I have an association where driveways are limited common elements. That's a limited common element. And the second question I can't read.
If I can add to that too, limited common elements are, if you look at your declarations, it will define what your common elements are and what your limited common elements are. So you need to look at your declaration. And while I've got the mic, inspection of units, I did talk about the inspection, and for the, what was it, the high-risk components, we usually hire a plumbing company. And usually we have a maintenance person accompany that employee. It's usually, you know, a plumbing company or a plumbing contractor or a plumbing consultant or a contractor. And they will do, mainly because the components that they're looking at are plumbing, you know, like the washer hoses, the valves, the toilets. So it's a plumber. And you can do a contractor, but it's not a board member, at least not in my experience. The people that I know who have done these inspections, it's usually you contract with a company and you have an association employee accompany that person to the various units. And, you know, there's usually a schedule, so everybody knows when that person is coming. So it's not a board member. And the second question is executive meetings, and it's like the board has had monthly executive meetings for undisclosed legal matters. Do owners have a right to know about what happens? And the answer is no, mainly because legal matters are issues that are pending. And sometimes there are very, sensitive issues that need to be confidential. Sometimes the attorney is there, and so there's an issue of an attorney-client privilege. So usually those issues are not made public, mainly because, you don't want to be discussing confidential issues with members of the association who might know some of the parties or, might be, otherwise involved. So so those matters are confidential, are not public. And there are minutes of executive sessions. They are separate. They are not included with the minutes of the regular meeting. And those minutes of the executive session are not made public to the unit owners because they relate to confidential matters. And usually what happens in executive session are legal matters, personnel matters. In other words, if an employee is being disciplined, or maybe you're talking about firing somebody, you don't want to make those discussions public. And so they are confidential. And there's another question, but I will get back to that.
Okay, well, I'm going to ask you this question. I'm going to knock out three. Who is responsible for the loss if an owner causes loss to others? Does the causing owner's HO6 pay for all affected owners? No. Everybody's own HO6 has to take care of your upgrades, your contents, your loss of use, not the HO6 of the owner who causes the claim. Only if I am negligent, and that's very hard to prove, I have to be legally liable, negligent for what I did, for my homeowners to cover your damage. So everybody who lives below me has to have an HO6, and that HO6 will take care of your hotel expense, it'll take care of your contents, not mine who caused the claim. Okay, because accidents happen in condo land, just like they happen in your house if you had a single-family home. So you have to have your own policy to take care of you. If you don't have a policy, it's out-of-pocket time. Okay, so the HO6 is a great little policy that everybody should have. Question here says, who's going to cover my property that has to be stored while they're redoing my unit? Your HO6 is. If you don't have an HO6, you're paying for it. Okay, not the unit owner who caused the claim. It's your money, it's your stuff, you insure it. Okay? This HO6 is an important little policy. It is recommended that the board make a written resolution on how the deductible is to be assessed. It's hard to make a written resolution. 514B wrote it down. You got three options. You pay for it out of association funds, you charge it to the unit owner who caused the claim, or you divide it. So you have to look at each claim, because you have to say, well, what happened here? Well, Sue's washing machine leaked. Well, then Sue's paying the deductible. Or you say, gee, it came from the common element. The plumber found a diaper in there. We don't know which kids did it. Or we found a toy in the pipe. Or we found a Coke bottle. These are all things we find. So we're going to, in that instance, the board makes the decision to say, well, we're going to divide it amongst the deductible amongst all the owners. If you have your HO6, you should not care. Your insurance company is there for you. Three questions found. Next.
Okay.
On your HO6, but if you're paying the deductible on your HO6, it's usually $500 is the standard deductible. You've probably had to use loss of use. You probably had to be moved out. You probably had some damage to your upgrades, and you have the loss assessment. So it's $500 is the most you should be out as your own personal deductible. If you can't afford a $500 deductible, buy the policy with $250. It goes as low as $250. Okay? That's your decision. But it's just like when you park your car at Ala Moana Shopping Center and somebody hits it and leaves, it's your deductible. Okay? So you have to be realistic of what you can afford in case you do have to use your insurance. Thank you.
So I have a few questions here on board members. One of them concerns, I think it's really, what can an individual director do when it's discovered that a board president is behaving unethically? And violating their duty. Ideally, you would like that to think that all the other directors except the president would recognize this, because of course the president only serves at the will of the rest of the board. So ideally, the individual director would talk to the other board members and they would remove the person as president if the president's behaving unethically. If for some reason the other board members are not willing to act, you have a more difficult problem, because then you might have to either consider some type of mediation, arbitration, as Jane was explaining, or taking the matter to the owners. And it's never completely clear. You would hope the owners would have the same concerns as you, but ideally, if you're a director thinking or finding that the president's behaving unethically, the best thing would be if the other board members acted to remove him. Let's see. What can a director do if the board president, I think that might be a repeat. Let's see. Can a director sue another board member? Yes, this is America. Anyone can sue anyone. But what you would probably be trying to look at is if the director, the other director or the president is just completely unwilling to recognize what they should be doing, that may be the problem. You could probably consider a mediation, as Jane pointed out. The Real Estate Commission sponsors that and subsidizes it. So those might be things, but you could sue another director, you could sue the president. You might want to look at other options before you did that. Can the board president dictate most discussions? They are the presiding officer, but ultimately the directors also have a right to participate in the meeting, so I don't think that the director can dictate, the president cannot dictate decisions. Those are supposed to be made by the members of the board, and if they don't, then they have their own problems too. But the reality is, that I'm assuming that's what's happening here, is sometimes if you have a very strong president, they tell board members what they're going to decide. And I'm not sure what to tell you about that type of problem, because you really have to, as a board, decide. If you are the minority director who doesn't feel this is correct and the rest of the people just sit there like bumps on a log and let the president tell them what to do, you do have some problems. And that's when you might have to consider trying to force a mediation, consider arbitration, something like that.
If I can just add to that, the statute does, as part of your fiduciary duty as a director, you have to exercise your independent judgment. And if you're sued as a board, and Sue will probably, be able to, expand on this, and if, under your officers and directors, the issue may come up, if the board president acted as a dictator and you never stood up and said anything, and didn't put it on the record that you disagreed, then your officers, then your DNO may not protect you in a lawsuit if it is discovered that you never took any action to stop that person. And there was a lawsuit many years ago where a vice president was held liable for breach of fiduciary duty because he didn't stop the president. And in that case, I knew the president. There's no way in hell anybody would have been able to stop her. But he was determined liable, and the judge entered a decision against him. And so, so if you're on a board with a dictator, I mean, you need to, at least place on the record, or if you can't, put it on the record, at least have emails or something to say that you opposed what he was doing or she was doing, and objected to that.
There's another question here about to what extent are current board members held responsible for past boards' actions? For example, not budgeting the reserves for large capital replacements. If the past board members who are owners challenge or the current board for the fact that there's not enough financial money needed, because, I mean, if a board member, an owner came up to me and said that hey, there's not enough money, we're holding you responsible, current board, all I would do is say, gee, I've been on the board now for a year. I looked at the financials when you were on the board, dears, and here's what you've had. Here's how much more we've put aside. And don't worry, I'll be upping your maintenance fees very shortly, so we'll have more in reserves. Give it back to them, because don't let people sit there and tell you as you sit on the board that you're wrong for something that you just inherited. You do have to take care of what you inherited and turn it around as a board member. And if you know you're under-reserved and you're underinsured or whatever the case may be, deal with it so that these kinds of things can't happen to you.
I have a question, well, a series of questions, but I'm just going to address a couple of them. What is the legitimate purpose for a house rule limiting the weight of dogs? That's a real touchy one, but generally speaking, associations want to limit the size of the dog because, especially if it's a high-rise and you have elevators, there's not much room for too many people if you have a Great Dane sitting in there with you. Secondly, there are a lot of people who are deathly afraid of dogs, and then so the limitation on the size of dogs is, I think, just to make it a more manageable situation. I am always concerned when a board uses a weight limit, because when a dog comes in, and if it's a puppy in particular, they tend to grow, and then when they grow and they gain weight, and like humans, if they get fat, you can't ask them to cut a leg to get them under the weight limit. So that's often tough. And what are you going to do? Are you going to have weigh-ins on the dogs? So those are problematic. How would you structure a house rule to manage noxious odors in an apartment from another apartment? And this also is a real tough one, because I've had this issue raised that my neighbor cooks Korean food and it's just really bad. My neighbor always has fish and that's really bad. And those are issues that I don't think lend themselves to a very easy response. And, you may ask them if they can put some doorstop underneath to keep the odors from drifting out, but aside from that, it's very difficult. I mean, unfortunately, you give up certain rights when you move into a community association like a condominium, and you can't legislate everything. And what may be a noxious odor to you, to the person cooking it, obviously, it's not a problem.
I have a question here about aging in place. Who can an association manager contact to conduct an evaluation? Catholic Charities was the organization, and I've been in contact with them over the years. They still do that. They will, what happens is you contact them, they will come in and do an assessment. And the statute makes it really clear. If you call Catholic Charities, their client is the resident who is living in the unit, even though the association will be paying the fee. And then under the association rules, I mean, you can assess that owner for the cost of that. And if it's a mental disability, it's Helping Hands, because they have psychiatrists on staff, and they also are caseworkers. And what they do is and I've seen it both ways. If the unit owner refuses to deal with that caseworker, there's not a whole lot you can do. And, that's the quandary. I mean, what do you do if they don't cooperate? And that is the topic of probably a resolution I'm working with a legislator with, we have a situation where you have people living in condominiums who have mental or, issues where they don't take care of their homes. And no matter what you do, they are into denial. They will tell you, leave me alone, this is my home, you can't tell me what to do. But they have cockroaches that go into other units. There are smells that emanate. that, you know, people complain about, and there's really not a whole lot associations can do. And I am working with a legislator, and probably next year we'll be setting up a task force, because we've had issues where you call the Office of Aging or Adult Protective Services, and they will tell you, oh, there's nothing we can do. If they choose to live like that, then there's nothing we can do. That's even for a family member, because a lot of associations, when they have a situation like that, the association management will call the family member. That's why, you know, you all have the cards that say, who do we contact in case of an emergency? You contact the family member, and even with the family member, Adult Protective Services will say, there's nothing we can do. And so we recognize that there is an issue regarding that, and we will be working with the legislature to try to set up a task force with different state agencies to assist associations and family members on how to deal with those, you know, people who just resist, you know, help. But for Catholic Charities, I know, will help you with your aging people. And I have one other question too. Feral cats. What if a tenant is feeding cats on public property, like on the sidewalks? What can you do? There's really nothing the association can do, but you can. I know that there was an issue somebody was talking about, you know, the damage that feral cats can do. They cause maintenance issues. Your maintenance fees can go up, and you know, you need to start educating your residents that, you know, this type of that they can't. They should not be feeding the animals, the feral animals, because it causes problems. It will result in health and safety concerns, and it will raise their maintenance fees. And so it's an education problem. It's not anything that the association can affirmatively stop.
Okay, I got a couple of them. This one might be a little tricky one. Can the board decide to roll over excess funds at fiscal year end into a special operating reserve? And then there's a second part of it relating to the rollover resolution that happens every annual meeting. They said that they thought the rollover resolution says that only, you know, those funds will be spent first, so how can you put it into a special operating reserve? So if you're fortunate enough to have a surplus of funds at the end of the year and you have a lot of money in your operating account, it does make sense to create a special reserve. Your checking accounts probably don't make a lot of interest, so put it into a savings account and create that special reserve. But if you adopt the rollover resolution that says you're supposed to spend that money first, well, don't put that money into the special reserves. Use your, you know, old funds that you've had in the checking account, put that into a special reserve, so that way you comply with the rollover resolution. And then a second one I have, for the annual reserve study, what's a good reference for interest rate and inflation rate? The reserve study is usually a 20-year prediction. So I like to use inflation, the average of the past 20 years, and that's a pretty good indication of inflation rate. And then interest rate, the law provides for how to calculate the interest rate, and I know it's an average, and I know it can't go below or above. Off the top of my head, it's in 514B, and I got to look that one up. But off the top of my head, I can't tell you what that one is.
I have a fairly common question. The board president and property manager refused to answer my email questions. What do you suggest I do? I'm not actually sure they necessarily have to. The interaction between owners and the board and the property manager is supposed to be really at the meetings. And so, as Jane pointed out, sometimes that is not very well done. But the board president is a volunteer. They're not necessarily on duty 24/7. The property manager, if you're asking for documents or something like that, something they're required to provide by law. But if you just have questions you'd like answered, I don't know that there's any particular obligation to answer questions unless they are something covered by the law. And then there's a question about the president's newsletter column had unfounded statements and zero facts, which the person who gave this, I guess we're pretty familiar with that now. What are my options? Well, you could try to get the president to correct it, but it sounds like he wouldn't. The question would be if there's something about you, for example, that you've done something terrible, you could consider sending out your response. You could go to a board meeting and raise it. Try and put the president on the spot. Otherwise, again, Jane was suggesting it's a bit of a fallback, but you've got mediation, arbitration. You could try and have it corrected that way. And then the only other ones, there were questions about my statement that employment at will is no longer necessarily the law. The theory of employment at will is you could terminate an employee at any time for no reason whatsoever. I think if you talk to people who specialize in employment law, generally you want to have a nice, clear record nowadays of why you're doing it and that it was justified, because it seems as if decisions being made by the courts are such that you can't just tell someone you're done, go away. You should have some record that there's a justification for it. So the employment at will, the idea you could just tell an employee, sorry, you're done, leave tomorrow. It seems as if the courts are saying not necessarily, because there may be improper motives for termination, which we will look at. And that's why I think if you talk to an employment law attorney, they will tell you that you should try to be very careful about dealing with employees, and I think that's something to remember. And there were questions about what is the board's role in dealing with a resident manager. And essentially, you are the representative of the employer. The association's the employer. You're the representative. You are supposed to supervise, make sure they do their job, make sure they don't create problems for other residents. That would be your responsibility. But if you have a problem employee, I would suggest you consider, again, don't cheap it out, consider speaking to an attorney who specializes in employment law, because it is sometimes difficult to know the parameters as the employer, as the representative employer, of what you can and can't do. And it's probably worth your while spending an hour or two talking to an employment lawyer, because difficult employees are often very willing to press their rights and bring claims with either Labor Department or someone else. So that would be my suggestion. It is your responsibility as a board, but be very careful how you exercise that responsibility.
I have a question, asking where in the statute is the aging in place, and I don't have it right on top of my head. If the person who asked this question could see me after after this and give me some contact information, I will get back to you with that. And just as an aside, I was talking to Council Member Ann Kobayashi, who is now head of Parks and Recreation. She tells me that the Office of Aging for the Oahu County is under her jurisdiction. And so she's looking into a program and trying to get the Office of Aging to try to get different contractors, who do cleaning or taking people to their doctor's appointments, all these services for disabled and aging people, and so that it would be, you can call one place, the Office of Aging, Oahu County, and get that information. And I commend her for doing that. She told me that she would be, implementing that since that comes under her jurisdiction. And that would be a resource for property management people. And we have had seminars on aging in place, and if anybody is interested, they should be talking to their boards about getting their cooperation. If you can get a vendor to come to your building to do cleaning for people who can't do it, and have parking available for them, and you have a building who have people who are away at work all day, ask them if they can use the parking stall for these vendors, to come to the building and provide services. And if you can get if you can get vendors to come and provide these services for a bunch of people, maybe they will lower their costs. And so that's something that owners and boards can work together and provide their residents with these alternatives. And so that's something that been encouraging over the years when we do these seminars on aging in place. And there is a provision in the statute, and whoever, sent this question, if you will see me afterwards, I will get back to you with that information.
Okay, we're just about out of time, so what I'm going to do is I'm going to do the so-called, like on the quiz shows, the lightning round, and we'll go on one question for each of us going down. The question I'm going to deal with is unruly children. I'm afraid of being tripped in the lobby, pool deck, etc., by these unruly children. Everything has been done by management, but to no avail. What next? Wait until I'm knocked out. Actually, if it's a situation of unruly children in the common elements and you know who they belong to, in other words, who the parents are, you can cite the owner of the unit where the child resides, and that's the most effective way because, as John said, you have to build a record. You cite them, you can find them, and when you find them, you usually get the owner's undivided attention. And if the parents actually are the unit owners, then you find them. And if, after you reach the max out, then it's sent to association council, and you basically get a restraining order from the court or an order from the court that they have to supervise the children. They can't run amok. So you don't let them essentially commandeer the common elements to the adverse impact on all of the other residents.
Okay, there was a question about what documents can be withheld from owners. If you look in Jane's materials, there's a long list of things you have to provide, and then a paragraph that says, if you don't, you have to provide these. Other documents can be withheld, but basically you have to have a good reason for doing so. So that's, I think, and it is in Jane's materials. It does explain that you must provide a long list of things, but not, you can withhold things not specifically listed.
And that's 514B 154. That's the omnibus, whatever documents you want statute. And I've done all my questions.
Okay. I got one here that's more property management than reserves, but what communication methods besides mail you think works efficiently for the association? A lot of associations keep track of emails. They have email trees. One of my associations, we just had our annual meeting, and we were going into the annual meeting with less than quorum. So we have phone numbers for all our members, so we made phone calls. There's also new technologies out there for phone applications. One of them called the Condo app, where a resident manager can send notifications, immediate if you have a water shutdown or elevators are down, that sort of thing. If you have this app on your phone, they can send notifications and it'll pop up on your phone. So I think those are good methods.
Okay, I have a question that says insurance on buildings that are not on plans. Your insurance agent won't know if it hasn't been. When you say they're not on plans, they're probably illegally built. And so you're saying, why are we insuring them? Because we probably don't know they're illegally built, but we do insure all that we see. So this person says, can I contact the city and county? Go for it. Not a problem. Then she says, he says, a common wall neighbor builds a shed attached to their common wall. And did they have the right to do that? Again, building department, possibly, I'm not sure. But it's not an insurance question, but you're going to have to see whether it is illegal or not for somebody to attach something to your wall, or is that side their wall? I have no idea. That's what neighbors' disputes are all about. And one other question said that, why can't the D&O insurance and other parts of insurance policy take the place of contractual liability coverage? The director, every policy covers certain things. This person is asking is, they want one policy to cover something else that may be not on their policy. You can't make the property policy cover liability. You can't make the liability policy cover property. The D&O policy covers board decisions. Contractual liability is on your general liability policy if you have it, and that's where it is. And that's the policy that's going to provide the coverage. If you don't have contractual liability on your general liability policy, there's no other policy that's going to step in for you on that issue.
Okay, I've got the site for the aging in place. It's 514B-142. Okay, so it's 514B 142. It's the aging in place provision in the condo statute. Thank you.
Okay, I want to thank all of you for taking your time to join us this morning. I'd also ask that you give the speakers a round of applause, please. If you haven't filled out the evaluations, would you please do so and leave them on the table on your way out? Thank you for coming.